Members, this is the session on judiciary and the administration of justice. We welcome the Secretary for Justice, Mr. Paul Lam, and also the Judiciary Administrator, Ms. Esther Leung, and the team to attend this session. I will first invite Mr. Paul Lam to give us some brief remarks, and then Ms. Esther Leung. Please press the button now. Secretary for Justice. Chairman, members, as the only common law jurisdiction in our country under one country, two systems, Hong Kong enjoys unique and unrivaled strengths. To fully implement the initiatives mentioned in the budgets and proactively align with the National 15th Five-Year Plan, the Department of Justice will further enhance Hong Kong's internationalized, high-standard and high-caliber legal services system and the related infrastructure through a number of key projects. By doing so, we will play a more proactive role in national development, in the development of foreign-related legal system, as well as capacity building. The total estimated expenditure of the DOJ for this year is about $2,539.1 million, representing an increase of about 20.4% over the past year. That is 2025 to 6, but only a slight increase of about 1.2% over the original estimates of 2025 to 6. In particular, the estimate for cost and briefing out expenditure for this year is about $335.1 million higher than the revised estimates for the previous year, accounting for about 80% of the overall increase in the estimate. While the estimate was made based on the cases being handled and the impending or possible new cases, the actual expenditure will ultimately depend on the future developments and outcome of those cases and the expenditure arising from unforeseen cases. It is therefore not entirely within the control of the DOJ. From the questions raised on the estimates of expenditure, we note that members are particularly concerned about three areas of work, namely international legal and dispute resolution services, foreign-related legal talent training, and the support for mainland enterprises going global. I would like to speak briefly on these points. One, strengthening Hong Kong's position as an international legal and dispute resolution center. The establishment of the International Organization for Mediation, or IOMAD, in Hong Kong have strengthened our position as an international legal and dispute resolution services center. IOMAD is an independent intergovernmental organization. The government will not be directly involved in its operation or future plans. Nonetheless, we will fully support the promotion work of IOMAD. That includes organizing the Global Mediation Summit during our flagship event, Mediation Week, and encouraging enterprises to actively consider incorporating IOMAD's Model Dispute Resolution Clause into their international contracts, thereby strengthening legal safeguards for foreign-related matters. The DOJ will also enhance international legal exchanges and cooperation in order to reinforce Hong Kong's position as the capital of mediation. 2. Developing Hong Kong into an international legal hub. We are preparing for the development of the Hong Kong International Legal Service Building next to the IOMAD headquarters as a landmark of the new international legal hub. With its preparatory work set to begin this year, the building will be home to the headquarters of the Hong Kong International Legal Talents Training Academy and international and local legal and dispute resolution services institutions. It will also feature venues for international legal conferences and facilities for international legal affairs research, arbitration, and mediation. This will not only foster synergy between IOMAD and various legal organizations, but also enhance legal exchanges and cooperation among Hong Kong, the mainland, and other jurisdictions, leveraging our global influence and significance as an international legal hub. 3. Building Hong Kong into an international hub for high-caliber legal talents. We have been making vigorous efforts to build Hong Kong into an international hub for high-caliber legal talents. Since its launch in November 2024, the Academy has, in collaboration with more than 20 international organizations, relevant mainland authorities, and local professional bodies, organized over 20 capacity-building programs within and outside Hong Kong for some 2,000 participants from Hong Kong, the mainland, and regions along the Belt and Road. While some of these programs were specifically designed for legal sectors in overseas countries, for example, those countries along the Belt and Road, the Chinese mainland, and Hong Kong, others brought together legal professionals from all these places. Looking ahead, the Academy will continue to organize more capacity-building programs to promote international legal talent exchanges so as to contribute our strengths to support the formulated rule of law construction of the country. 4. Strengthening the promotion of our mediation and arbitration services. To promote the development of dispute resolution services, we will strengthen the regulatory framework for accreditation and disciplinary matters of the mediation profession in Hong Kong and will take forward the legislative exercise to enhance the professional standards of the sector. We have launched the pilot scheme on sports dispute resolution to provide the sector with an efficient and convenient means of resolving sports disputes so as to develop Hong Kong into an international center for sports disputes resolution. 5. Strengthening the collaborative professional support for mainland enterprises. To harness our strengths in international professional services, the DOJ has fully launched the Hong Kong Professional Services Go Global platform last year and established the Expert Committee on Professional Services for Going Global this year to coordinate the professional services sectors in supporting the overseas expansion of mainland enterprises, with Hong Kong as the preferred platform. We will compile and publish panel lists of professional services providers supporting overseas expansion to facilitate enterprises' connections with professional services providers according to their needs. Looking ahead, we will continue to implement the policy initiatives on all fronts, strengthen the rule of law in our society, leverage the strengths of our common law system to connect the mainland with the rest of the world. We will align with the National 5-year Plan and support the country's rule of law construction and high-quality development. Thank you. Members are welcome to put forward questions. I will now invite Ms. Esther Leung to give us a briefing. Thank you, Chairman. The judiciary has the constitutional duty to ensure effective and efficient administration of justice. This is integral to upholding the rule of law and judicial independence in Hong Kong. Court business is an essential public service. While the demand for court services is entirely beyond our control, the judiciary is obliged to handle and dispose of all court cases and proceedings in a fair, reasonable, and efficient manner. In year 2026-7, the estimated expenditure for the judiciary is $2,906.3 million, an increase of 4.5% over the last year's revised estimate. The additional financial resources required are mainly for filling vacancies of JJOs and support staff at different ranks, as well as enhancing the efficiency of court operations through implementing various technology initiatives and engaging more deputy JJOs. To address the persistent shortfall of JJO manpower at different levels of court, particularly the High Court, the judiciary has been conducting more frequent open recruitment exercises in recent years for filling judicial vacancies and retaining experienced senior judges. Continual efforts are also being made to increase temporary judicial manpower, including recorders and deputy JJOs. For non-judicial manpower, considering the government's position of fiscal constraints, we are committed to containing the establishment size and redeploy our internal resources. The establishment of non-judicial manpower is expected to be reduced by 18 civil service posts in this year. In the following, I will report on the works of the judiciary. For court proceedings, due to the persistent heavy caseload at various levels of court, courts are heavily burdened. The total caseload last year was 536,600 cases, some 4% higher than the average in the past 5 years. Through the concerted efforts of JJOs and support staff, we have cleared an overall caseload of 514,000, which was 96% of the caseload received and 4% higher than the average in the past 5 years. We have taken proactive and multi-pronged measures to expedite court proceedings while steadfastly upholding the principles of justice. These include engaging additional judicial manpower, strengthening case management, promoting the use of mediation or other means of alternative dispute resolution, making greater use of technology, and enhancing court facilities. Overall speaking, the majority of civil cases across all court levels continue to meet target waiting times, and there are steady improvements in the waiting times for criminal proceedings. We have continued to accord priority to cases related to the 2019 Anti-Extradition Amendments Bill incidents and national security cases. As of last year, we have cleared around 2,300, or 97% of over 2,370 Anti-Extradition Amendments Bill cases, and about 230, or 88% of about 260 national security cases. With the majority of the remaining cases scheduled for trial this year, the impact of these cases on the average waiting times for other court proceedings is expected to subside gradually. Next, I will move on to leave application for judicial review relating to non-reform on claims. In this year, we will continue to cope with the continual influx of cases relating to non-reform on claims. To expedite the disposal of these cases, besides recruiting retired judges to serve as deputy judges of the Court of First Instance, We have launched a special scheme in February 2025, whereby eligible private practitioners from the legal sector are appointed as deputy CFI judges exclusively for handling these cases. This, together with the streamlining of administrative procedures and presentation of the judgment decision notice, has enhanced the efficiency of disposal of cases. Last year, the CFI has handled over 3,700 such cases, exceeding the number of last year by 1,000, representing 2.1 times the number of cases disposed of in year 2024. If this pattern continues, we expect to be able to clear off the backlog cases in a few years' time. Next, I will move on to the use of mediation in court proceedings. Over the past years, we have been making continual efforts to promote wider use of mediation at different levels of court as an important means of resolving disputes in lieu of litigation. Last year, the overall success rate of cases considered suitable for referral to mediation was about 60%. In the family court annexed mediation scheme involving the engagement of accredited freelance family mediators for suitable cases continue to achieve a high success rate of 89%. In the district court, the case settlement conference scheme, which was regularized last year, has proved effective in facilitating the settlement of general civil cases, with a success rate of 56%, saving litigation time and cost and reducing the adversarial nature of proceedings. Next, greater use of technology. We are committed to making greater use of technology for enhancing the efficiency of court operations. We are implementing a series of major technology initiatives. The Integrated Court Case Management System, or ICMS, is being implemented across all court levels for handling court-related documents electronically, including the civil proceedings of the High Court since June last year. In response to the judiciary's continual promotion efforts, the registration rate of law firms has recently reached 80%. The judiciary is planning to start mandating the use of the ICMS for all legally represented litigants in respect of case types where the electronic mode has been made available by phases, starting from the second half of this year. We have been engaging with the legal profession on the preparatory measures from mid-2026 and the mandatory regime later in the year. Meanwhile, we will continue with our outreaching efforts to promote and train more users, especially the law firms, to migrate to the electronic mode in preparation for the mandatory requirements. Remote hearing is another major technology initiative. So far, some 2,610 remote hearings have been conducted with positive experience. In January this year, pursuant to the relevant provisions of the Court's Remote Hearing Ordinance, the judiciary extended the use of remote hearing to non-trial criminal proceedings, starting with bail applications. This arrangement allows the persons in custody to attend from penal institutions instead of traveling to court, saving time and resources while avoiding transport-related risks. We will continue to make wider use of remote hearing in suitable proceedings. As regards the use of AI in court operations, the judiciary has been making active use of voice-to-text or VTT technology to enhance the efficiency in recording court proceedings and production of transcripts. Since December 2023, we have been using this VTT system for JJO's real-time note-taking during court hearings. In November last year, we launched a pilot arrangement to produce transcripts using VTT system for selected court hearings in the Court of Final Appeal building and High Court building. We will review this scheme's effectiveness, as well as keeping abreast of the developments of the VTT technology and optimize its use and explore new modes of operation. In parallel, we have been exploring the use of generative AI in the work of the judiciary. In July 2024, the judiciary promulgated its first set of guidelines to allow prudent and responsible use of generative AI for the JJOs and support staff. Also, the judiciary is drawing up guidelines on the use of generative AI for legal practitioners and other court users for consultation with the legal profession later this year. The judiciary will continue to keep abreast of developments in AI and consider its potential use in judicial and non-judicial work. To meet the new challenges, brought about by rapid developments and increasing use of information technology in the work environment, we have continually been updating the IT security policy and strengthening IT security measures in accordance with the relevant IT security standards set by the government. The IT infrastructure facilities of the new district court building have been designed on the basis of the highest level of IT security stipulated by the government. Finally, on court security. Given court premises are part of Hong Kong's critical infrastructure, we have been making continual efforts to ensure the security of law court buildings and safety of court users through appropriate crowd management and security measures. These include ticketing arrangements, use of CCTV recordings, and deployment of appropriate security manpower. Overall speaking, we will make continued efforts to explore feasible ways and means of enhancing the efficiency of judiciary administration and provide better quality services to court users and members of the public. Thank you. I will be pleased to answer members' questions. Thank you.
Thank you. 7 members are waiting to speak. We have ample time, so let's do 4 minutes per member, questions and answers inclusive. We'll start with Mr. Nick Chen. Thank you. My question has to do with reply SJ002 and SJ006. So let's start with 002. I start by thanking the authorities for promoting our professional services and also for supporting mainland businesses in going global. So we have this PASS program. It's a professional advisory support services. Now, for the industry, they often go visit different places on their own. They go to those legal forums. They go on sharing sessions. Meaning those industry players went without the law society or the bar association, and they had a hard time applying for PASS. Approval took too long. So I wonder, in future funding, can we set aside money to support industry players who go overseas to tell China's story and Hong Kong's story well? Now, my second question has to do with the Hong Kong International Legal Talent Training Academy. The results have been impressive. We have done well. People from far and wide have come here for the programs. So can we make use of existing resources or earmarked resources for certificate programs in connection or in partnership with local law schools? Secretary, I will say a few words on going global, and then I'll see if my deputy has anything to add. Now, on PASS and the funding for the scheme, I have experience of the scheme. Indeed, the procedure gets complicated and it's challenging. The funding for PASS comes from the CEDB or Commerce and Economic Development Bureau. We have been in touch with the CEDB, so we start by enhancing the scheme. That scheme isn't just for the legal sector, but indeed we should make good use of the scheme. So we want to first hear from the industry. We try to enhance it first. On having standalone support for the legal sector, we don't have such plans yet. We have to make sure that resources are properly allocated. That's why we say we start by enhancing the scheme so that the industry can go overseas and tell stories of Hong Kong and China well. Now, maybe my deputy will have more to say on this. Now I turn to legal talent training. We have been exploring partnership programs. Our resources are finite. Sharing knowledge requires partnerships. We do work with institutions. We work with mainland institutions, for example. But we want to take a more practical focus for all our collaboration projects. So we don't want our program to be just a joint certificate program with a university. For a year or so, we have had more than 20 collaboration projects. Most such projects were short-term. So examples include exchange sessions with mainland judges or professionals from arbitration rather than certificate programs or diploma programs with universities. We do have collaboration, but we may go for something other than diplomas. Instead, we want more bespoke, more targeted programs. So that's our focus. Maybe my deputy will have something to say on past funding. The Deputy Secretary for Justice. As the Secretary said, now, we have this Go Global platform for professional services. The DOJ on its own, we also work with industries and the Trade Development Council. We visit the mainland and overseas to promote Hong Kong's professional services. Indeed, there may be challenges during the application. That's what the sector has told us. We pass on the comments to the team working on the funding so that they can enhance the process. So we will continue to pass on the feedback to the team. Now, a drawback with setting up our own fund. Let's start with going global. When you say professional services, it's not just about legal services. There's financial services, there's accounting, there's branding. If you have a standalone legal support fund, will that lead to other industries having their own standalone funds, and you end up with overlapping structures? So if something is not good enough about the existing system, we gather feedback, we enhance it so that we make life easier for those industries. Mr. Dennis Leung, SJ049, that's my concern. We know court resources are precious. That's why the government has been driving mediation. My question covered the pilot scheme on community mediation. 160 people were trained under that program, but this is not exactly a professional mediation training program. That program is just to give frontline officers skills so that they resolve issues at source. Can we have more details about this pilot scheme? So what scenarios are covered and what's the substance of the program? After people are trained under the scheme, do we have tracking studies so that we can tell whether these people actually apply what they have learned and end up resolving problems at source? And once we have the information, will we further adjust the pilot scheme so that we can strengthen the program, make the program better, and we end up resolving issues in the community to take pressure off the courts? Secretary. I thank Mr. Leung for his question. He made a good point. It's a pilot scheme. It's still ongoing. We're still monitoring the success of the scheme. As the member observed, this pilot scheme is targeted. Mediation covers a wide range of areas. For this scheme, it's about community mediation because it's focusing on the day-to-day issues people run into, such as building management. Water seepage is something we're all familiar with. That's why this pilot scheme has a focus. We target property management companies that deal with disputes between residents. So that's the focus of the scheme. So the program covers basic mediation skills and also issues specifically about water seepage. So the program covers mediation in general and also specifically water seepage and building management. So the knowledge sharing covers that, and that is the focus of the pilot scheme. The scheme has been well received. 7 sessions were held, 160 people were covered, but the program has struggled to keep up with the demand. We will keep pursuing this pilot scheme. Hopefully we can have 9 sessions by May this year. We want to have 21 sessions in total. And only then can we reach the goal of the pilot scheme as a whole. After the pilot scheme, we will review the scheme, we will follow up, we will look at the outcome. This time we're working with the Environment and Ecology Bureau. We also welcome future collaboration with other bureaus. But let's give this pilot scheme some time. So far, the feedback has been positive. People found this pilot scheme helpful. Property management staff are now better placed in resolving disputes between residents, and that also means taking pressure off our judiciary. We will keep an eye on the pilot scheme. In due course, we will update members on the progress of this pilot scheme. Mr. Holden Chow. JA007, that's my own question. My question has to do with the Small Claims Tribunal. Local residents told me that they had positive things to say about the Small Claims Tribunal. At the Small Claims Tribunal, people didn't have to hire a lawyer and they could sort out disputes involving $75,000 or less at the tribunal. Now I'm looking at the reply. Every year at the SBT, the case count is growing. The processing time is actually shorter than the target. The target is 60 days, but actually in over 41 days a case is disposed of. That points to efficiency at the SBT. But then let's look at the establishment, 80 officers. So my first question is, the SBT is doing fine, and its workload is heavy. Without the involvement of lawyers, the judge there, or the adjudicator there, takes on all the legal work. So that means a lot of work for both the adjudicator and all the supporting officers. So I wonder, can we expand the establishment? Can we just take on more officers? Now I also put in a question. The jurisdiction of the SBT went up from $50,000 to $75,000. I put forward that idea, so I wonder, if possible, can we consider further increasing the jurisdiction to $100,000 so that the SBT can serve more people? Of course, this will also be subject to manpower and resources from the judiciary. I just want to find out more. Thank you. Who will take the question, please? This is a question for the judiciary. Thank you. I thank Mr. Chow for his questions. So all claimants at the SBT are unrepresented. We get the impression that more manpower is needed when no lawyer is involved. At the SBT, most cases involve very small claims. So whether we can raise the jurisdiction to $100,000. Now the jurisdiction now is at $75,000. In fact, we're seeing fewer cases that are close to this limit. The share of such claims is shrinking. So we don't see a notable increase in the size of the claims. And that means we don't really see a need to raise the jurisdiction to $100,000. So let's also bear in mind that amounts over $75,000 currently go to the district court. Is it really right for those cases to come to the SBT instead? So we have to be careful. Now, on the operation of SBTs, 90% of the 50,000 plus cases at the SBT required no hearing. Many staff members at the SBT assisted the adjudicator by analyzing the case details for the claimant. So they try to resolve the issues without going through the proceedings. In some cases, mediation took care of the issues. Only 10% of the 50,000 plus cases every year required proceedings. That's why the waiting time hit the target. That's because not every case required proceedings, and we will keep working toward this goal. If we need more manpower, we will still be able to deploy people from the magistracies to the SBT. Dr. Thomas So. Thank you, Chairman. JA019 and JA020. The questions have to do with judiciary manpower and efficiency. So, two questions. First, on hiring more judges. What's the target? Now, I'm looking at the reply. The judiciary does not give me a specific annual target of recruitment for judges. We all know about the shortage of judges. The reply does not give me a specific figure. It simply says more frequent open recruitment as a strategy. It says the judiciary tries to recruit talent from the legal sector. Now we can see short-term recruitment. We have seen deputy judges, recorders, and also judicial officers. So I can see at one point we got 40 such short-term appointments, deputy judges, recorders at different levels of court. My question is, the shortage of judges is a long-standing issue. We will have a target, a specific target for 2026. How many judges are we looking to hire? How many permanent magistrates? What are the judiciary's criteria for deciding whether you have enough judges for the cases? My second question has to do with the deputy judges at the High Court. The High Court sees the biggest shortage of judges. Most deputy judges were barristers. But then there are many senior litigation solicitors, and more than 100 of such solicitors have higher rights of audience. So, does the judiciary have measures to encourage these litigation solicitors to become deputy judges? If so, what are the details? I also have a question about the time limit for issuing judgments. It's JA009. Practice directions have laid down different timelines for handing down judgments. The reply says 6,600 cases. It says, in most cases, the judgments were handed down within the timeline. But the reply does not say whether there will be a more specific deadline. The reply says most of the cases, but then we have tens of thousands of cases every year. From my experience, from what I've heard from my sector, some cases had to wait a year or more than a year for the judgment. Even if you miss the target for 10 or 20% of the cases, our status as a legal status will be affected. You have 4 minutes for questions and answers. You have used 3 minutes. I will stop here. I'll let them reply.
Judiciary Administrator. Thank you, Chairman. Thank you, Dr. Thomas So, for a series of questions. I will answer them one by one. First of all, concerning the recruitment of judges for the High Court as well as other JJOs, over the past few years, we have been actively taking forward recruitment exercises. In the previous round of recruitment, we have recruited some 25 additional JJOs for each level of courts. Near the end last year, we have just completed a recruitment exercise for CFI judges, and we will begin to conduct recruitment for other levels of courts this year. We will conduct a targeted recruitment exercise for those court levels with particular large manpower shortage. We will not set a cap on the number of candidates recruited. Now, according to Basic Law Article 92, JJOs are selected based on their capability as well as their characters and decencies. The Judicial Officer Recommendation Committee would recommend the candidates to the Chief Executive for appointments, and we will follow that mechanism. Now, for deputy judges, now for candidates who are suitable to be promoted to judges at the Court of Final Appeal at the highest level of court, lawyers as well as other JJOs may recommend themselves or other eligible candidates to the High Court for appointment. For suitable candidates, they would be appointed as deputy judges to alleviate the workload. During regular recruitment exercises, these deputy judges will also be eligible candidates. Another question concerning the practical guidelines set in year 2022. Upon conclusion of trials, the judges must hand down a judgment within a reasonable period of time. Now, in recent years, among the 6,000 judgments handed down, less than 10% have failed to meet the target. That doesn't mean we are not following up on these cases which fail to meet the time frame. There are different reasons. For some cases, the cases are more complicated and require more time for writing the judgments, and some judges have exceedingly busy schedules. That's why they have applied for a delay with the judiciary as well as the parties. So we will tackle it from different angles. First of all, enhancing recruitment and also streamlining court proceedings, and also encourage the use of mediation. This question has taken up 7 minutes of time, a significant overrun compared with other questions. So I remind members you have to save sufficient time for the officials to answer the questions. Otherwise, it would be unfair to other members. Professor Priscilla Leung. Thank you, Chairman. I would like to follow up on my question. SJ 34 and JA 20. I declare interest. I am an expert member of the Hong Kong International Legal Talent Training Academy. Now, concerning the reply I have received. Now, under the framework of the National 15 Five-Year Plan, the Hong Kong legal profession has been given significant opportunities. We have a huge role to play in terms of foreign-related matters. However, in the reply you have given me, you have really skimmed words. Now, you mentioned promoting the program as well as inviting international legal scholars, but there is no breakdown in terms of the manpower allocated to different tasks. If there is insufficient manpower, how can we fully align the legal profession with the National 15 Five-Year Plan in terms of alignment of rules and infrastructure? Now, the second question is about is for the judiciary. Waiting time for trial is long, and there is insufficient judges. You always say that you are actively attracting talents from the legal profession. Actually, there are lots of graduates from the free law schools, and also there are graduates returning from overseas. I know some law graduates who have graduated for 10 years, but there is no way for them to enter the judiciary. Is there a way to recruit these wasted talents? Rumor has it that they have to join certain clubs and formulate ties with senior judges to get recommended. I hope that's not the case. We have a lot of committed legal talents. Shouldn't you be more proactive in attracting junior legal workers to become judges? Secretary, thank you, Professor Leung, for acknowledging that we are frugal, but we understand that we need to have sufficient manpower to take forward our work. That's why we have been asking for the electrical support. Now, so far, there are 4 supernumerary time-limited posts lasting 5 years each. Now, there is Dr. Yang Ning, which we are all very familiar with, and the other candidates are redeployed from my office. So it's really my hope that we can achieve what we set out to do. We want to live up to the aspiration of the country on us. So at an opportune time, we will apply to electrical for more funding. At the moment, we are trying to optimize the use of resources through innovative ways. I thank Professor Leung for raising this question. At an opportune time, we will come back to ask for member support. Any supplements from the Judiciary Administrator? Thank you, Chairman, and thank you, Professor Leung, for your question. All our recruitment exercises are conducted in public. We would post an advertisement publicly, and all those potential candidates have to apply for the job. They will not simply get recommended by a senior figure. Over the past few years, to let more members of the public know that we are conducting a recruitment exercise, we have conducted sharings through the 2 law associations, where serving judges would explain the recruitment process as well as the welfare and remuneration packages to the candidates. That's why the recruitment results in the previous round of exercise has been more successful than before. And also the presiding officers at different levels, of course, welcome junior legal professionals to serve as deputy magistrates or judges to test their skills. And then during open recruitment, they will also be eligible for selection. We will seek to promote the profession to more members of the public. Ms. Judy Chen, thank you. My question is JA 005 and 6. Now in question 006, that's the waiting time for small claims tribunal and so on. I think the waiting time has been kept at an optimal level. But lands tribunal is another matter. I'm just comparing the figure for year 2024 and 5. There is a slight drop in terms of the case handle. For example, property management cases, they drop of 30%. Cases concerning leases, another drop of 20%. However, the waiting time is longer than before. In 2025, On average, the parties have to wait an additional 10 days to have the cases heard. Is that because of shortage of manpower? Question 006 on mediation. I always encourage my constituents to choose mediation instead of litigation to resolve disputes. Now, in terms of family disputes and small claims, more than 70% of these cases can be resolved through mediation. Now, again, in the area of property management, the success rate is below 50%, and also the number of cases resolved through mediation is much lower than family cases, 100, and small claims mediation, 200. For property management, there are only 10 odd success cases. Is it because the lack of understanding for the buildings ordinance on the part of mediators? Thank you.
Judiciary Administrator. I thank Ms. Chen for her questions about mediation and also family cases and building management cases. Now, at the family court, there are roughly 20,000 divorce cases. Cases that required proceedings because of disputes made up just 60% of the cases. Often, mediation or other forms of dispute resolution were needed. The court adopted different mediation options, different schemes were adopted to achieve mediation. So the judges had to choose the right cases for mediation, and then the success rate will be higher. Not every case is good for mediation. So with the pilot scheme at the family court, we have achieved some success with certain schemes, and then based on the successful experience, we will refer more appropriate cases to mediation, and that will take pressure off the family court judges, and in the end, that will mean greater efficiency. Now, for the Lands Tribunal, more than 80% of the cases have gone through alternative dispute resolution. For tenancy cases and building management cases, these cases made up the bulk of the cases at the Lands Tribunal. But you cannot make an apple-to-apple comparison between the Lands Tribunal and the family court because the cases are different. Where appropriate, we will refer the cases to mediation. Now, I asked two separate questions. My first question was why we got fewer cases, but the waiting time became longer. For these cases, there's a target waiting time, roughly 50 days. Over the past 2 years, the waiting time met the target. But the incoming cases varied in their complexity. So you see variations from year to year. Once you look at the average waiting time, we always seek to do even better. But more cases do not necessarily lead to longer waiting time, and vice versa. The waiting time at the Lands Tribunal has been relatively steady. Ms. Carmen Gan. My questions are for the judiciary, 010 and 012 and 013. So the first category of cases have to do with the leave for judicial review about non-refoulement cases. In 2025, we dealt with 3,700 such cases. Incoming cases in that year, 2,500 cases. So we disposed of more than 1,000 cases than the incoming cases. So that's welcome news. We also saw a 200% increase in the cases dealt with from 2024. From the reply, I see a new initiative. So we got retired judges to help out, and then we also got deputy judges specifically for the CFI to deal with non-refoulement cases. We got 5 retired judges and 16 qualified professionals on the task. The expenses amount to roughly $10 to $20 million. Every year we spend $1 billion of public money on bogus refugees. So what we are doing is a good idea. So can we have more people on the task instead of just having 21 people? Now my next question has to do with achieving greater efficiency through technology. JA013. In 2026 to 27, we will spend $379 million on information technology, and that makes up 13% of the judiciary's expenditure. The use of technology goes up by 9% year on year. And then in JA012, vacancy rates stand on 8%, and that it covers court judiciary clerks and court interpreters. So does it mean that with technology we will need fewer clerks and interpreters? Can we save that money? Judiciary Administrator. Thank you. On the non-refoulement cases, I thank the member for his support for our special initiative. When we have suitable candidates, we would like to hire more deputy judges specifically for non-refoulement claims, so that we can dispose of even more cases than incoming cases every year. We used to have 7,000 cases in our backlog. Starting from this year, that backlog has gone down to 6,800. If we have more people to deal with the cases and we streamline the procedures, we will be able to dispose of even more cases. Where permitted by resources, we can do more.
Second, on the use of technology. Every year, our expenditure on the usage of technology has been on the rise. Over the past 5 years, the accumulative increase has exceeded 50%. Our courts will only use more and more technologies. Now, for non-JJO staff, including court clerks, with the increase in the number of deputy judges and JJOs, we need more non-judicial staff to assist the operation of courts. For court interpreters, yes, we have the assistance of AI. However, at the highest level of interpretation, we still need human interpreters. So we need to maintain the existing establishments, but we will allocate more resources to support the usage of technology. Next, Mr. Wu Yingpeng. Thank you. My question is SJ042. Now, the government will provide a free office premise for the unification of private law international institutes. That's Unitroid. Now, the premises will be the former French mission building. Now, this is a very important move to attract an international legal institution to set up in Hong Kong. Now, Unitroid is a very important institution. However, the premises is also a very important government property as well as a legal monument. It is unique to our history as well as the development of our legal system. So has the government conducted a comprehensive assessment exercise? How long will the rent-free arrangements last, and will there be conditions on its usage? Which government official will take the question? Concerning the background, the French Missionary Building, or the former Court of Final Appeal building, at the moment there are already offices of the international legal institutions that include the Hague Legal Conference and also the Asian Legal Training Academy. So the property comes with string attached. That is, we need to use the property as part of our campaign to promote Hong Kong as an international legal hub. Now, since we have successfully attracted Unitroid to set up in Hong Kong, we must be able to offer the Unitroid with a high-quality premises comparable to those made available for other organizations. Now, with the support of the country and with the consent of Unitroid, we are offering this package to the Unitroid to come set up its first office outside of Rome in Italy. Now, there is not a limitation to the duration of the use of the premises. We hope the Unitroid will continue to operate in Hong Kong so as to maintain our status as an international legal hub. Of course, contracts will be signed with the Unitroid. For some, we can make the conditions public. However, part of the contract is also confidential. Ms. Lau Ka-Keung, thank you. JA008, a question from Ms. Carmen Kan. Now, the government replies in that there is no plan to use generative AI for legal analysis and generate judgments. Considerations must be made on privacy as well as some internal check and balance. So are there objective standards of consideration? For example, when AI models can achieve a certain percentage of accuracy, that the judiciary would consider using generative AI to generate court judgments. JA, thank you for the question on the use of generative AI technology. In 2025, when we published the first guideline, our focus was on under what situations JJOs and supporting staff are allowed to use generative AI technology. According to the guidelines, for less complicated and low-risk cases, we are already allowing the use of AI, for example, translation and also simple clerical tasks. However, for the core functions of the legal profession involving expertise, there is not one single AI model which can convince us that the accuracy can fulfill our standard. Nor is logic convincing, but this is an inevitable trend in the world. Other jurisdictions are aware of the possible use of AI in the legal profession, so we are still exploring options. For quality products in the market, under a limited circumstance, we would allow JJOs to use them. In the future, we don't rule out developing dedicated AI tools for the use by JJOs, but the main principle is that AI is an assistive tool. They cannot replace the independent judgments made by JJOs. We will keep tab of the situation and also make reference to other jurisdictions' development. We have finished the first round. For the second round, we have Professor Priscilla Leung and Dr. Thomas So, 4 minutes, questions and answers included. Professor Leung. Thank you, Chairman. First of all, I need to compliment the judiciary. SJ 034, as mentioned in paragraph 2, with a limited number of manpower, some 20 programs have been organized for 2,000 participants, and only 1 post has been added. This is extraordinary. Chairman, I know the government is in tight fiscal position and we need to cut the budget for many departments. However, there is an actual need to increase the manpower of the judiciary. Unless there is a group of reserve talents which are available for redeployments to the judiciary. Otherwise, we need to have sufficient manpower because we have high hopes for aligning the rules in the Bay Area. So I think we need to have a long-term plan to increase the manpower in the judiciary to develop foreign-related laws as well as aligning our rules with the mainland. And the second point for the JA. Many legal practitioners would serve as deputy judges or magistrates. But many legal professionals are unwilling to enter the judiciary at the early stages of their career. I think we need a long-term plan for retaining the talents. In terms of overseas judges, maybe we should cast the net wider among jurisdictions, other common law jurisdictions like Singapore. I think many judges would be willing to come if we try hard enough. So are you proactively attracting talents to become deputy judges, or are you relying on the voluntariness of the lawyers? So can you give us some details so that those potential candidates can have a better idea? Judiciary Administrator. Thank you, Chairman. Thank you, Professor Leung. For deputy judges, we regularly rely on deputy judges to replenish the manpower of permanent JJOs. It is also a good opportunity for legal talents to have a taste of a judge's work. And this is one of the pathways to become a permanent judge. Potential candidates can recommend themselves or suitable candidates to the presiding judges in different levels of courts. If they are considered suitable, they will be given an opportunity to serve on a short-term basis in the court. The window is also open to overseas judges. Of course, if they are not in Hong Kong, additional arrangements have to be made. However, in the past, we have invited suitable candidates from other common law jurisdictions to hear cases. Now, in terms of welfare and remuneration packages, we have enhanced the packages in recent years so as to retain senior judges. That's also effective in replenishing the manpower. Dr. Thomas So, I have a very brief question. Thank you, Chairman. Following up on the question of judicial effectiveness or efficiency. So I thank the JA for her reply. Indeed, there are some cases which are exceedingly complicated involving a long list of witnesses and exhibits, and they require a longer time to complete. However, that's the same for many overseas jurisdictions as well. Those jurisdictions are able to complete the cases swiftly. So I would like to encourage the judiciary to come up with ways to help JJOs complete the cases swifter. Otherwise, it would undermine our position as an international legal hub. So I hope there will be more follow-up work on the part of the judiciary. As mentioned by Professor Leung, we need to cast the net wider in recruiting JJOs. If all the cases are heard by deputy judges, it seems that the justice handed down in the courts would be deputized as well.
Any response from the judiciary administrator? We will continue the recruitment of regular judges, but I want to stress that deputy judges have the same power as regular judges. The judgments handed down by deputy judges have the same legal effect as those handed down by regular judges. Ms. Carmen Khan, I echo the comments made by Dr. Thomas So and Professor Priscilla Leung. For the Department of Justice, their total estimate is just $2.5 billion, and for the judiciary, it's $2.9 billion. Hong Kong is supposed to be an international legal service and dispute resolution services. Given that positioning, we can give the DOJ more money. The estimate this year is only edging up 1.2% from last year. Now I have some questions for the Department of Justice. There's a professional services go global platform, and that's led by the Deputy Secretary for Justice. An expert panel has been appointed. I welcome this panel. Businesses, especially mainland businesses in Hong Kong, welcome this idea. They want a directory to refer to for accounting and financial services. Now, I'm trying to pass on a question. So can service providers recommend themselves in specific professions? So maybe these are mediation professionals or financing specialists. And how will the selection work? Will the expert panel select potential members on the directory? Or can we set up an expert committee? Maybe we can save resources for the DOJ, or can we appoint a selection panel that works on an honorary basis? Deputy Secretary of Justice. Now, when it comes to helping professional services go global, such a directory is important. Mainland businesses looking to go global via Hong Kong want to find the right professional services. That information does not always reach the businesses in full. When I went overseas, I talked to the businesses that have gone global. The way it works now is the word of mouth. So an aspiring business talks to another business that has managed to go global. So we don't have information transparency here. This directory can improve the situation. And we're almost done with compiling this directory. We will be able to announce it soon. Now, we do want transparency in the compiling of this directory, this panel list. Industry players can recommend themselves. They have to indicate not just an interest. They have to tell us about their track record. So what are the industries covered? What work have they done? They can tell us about the success stories, their past results. We look at the information, we look at the data before we put those industry players on the panel list. Law firms in Hong Kong are eligible for inclusion on the panel list. Barristers also took part. Arbitration bodies are also eligible. So these players will be reflected on the panel list for legal and dispute resolution services. So there will be a list for the legal services. We hope that this panel list will show mainland businesses which professional service providers they can turn to depending on where they're going and the stage of their development. We hope that this list will prove helpful for mainland entrepreneurs. Once we roll out the list, we will gather feedback and then we will keep enhancing the arrangement so that Hong Kong's professional services can truly help mainland businesses go global. So we will cover other professions as a next step. Is that the case? The chief executive tasked me with the work on legal, accounting, and financial services. For us at the DOJ, we start with the legal sector. And then we will apply the same model to other professional services so that mainland businesses get a better grasp of the professional services available in Hong Kong. 12 members asked questions at this session. The next session will start at 4:35 p.m. We will proceed with the break. Thank you.